Greetings and good day. Welcome to the Ikyan Shah Audio Notes series designed specifically for law students. More importantly, these notes are designed to help you write your answers efficiently within 35 to 40 minutes during the examination. Do like and share this video and subscribe this channel for regular updates. Let's start our today's topic. How company wound up voluntarily. Heading number 1. Introduction. By winding up a company is meant the end of the life of a company. A company is an artificial person. The termination of its existence is affected by law. The winding up of a company is a legal procedure in which all the affairs of the company are wound up. It is permanent closing down of the business of the company. Its assets and liabilities are determined, assets are sold out, and claims of the creditors met out of sale proceeds. The balance, if any, is distributed among the shareholders in proportionate to their shares. Heading number 2. Definition. When a company ceases to exist and its property is administered for the benefits of its creditors and member, it is called winding up. Heading number 3. Modes of winding up. According to the Companies Ordinance 1984, a company can be wound up by the following 3 ways. 1. Compulsory winding up by the court. 2. Voluntary winding up. 3. Winding up under the supervision of the court. Heading number 4. Voluntary winding up. It has 2 kinds. 1. Member voluntary winding up. 2. Creditors voluntary winding up. 1. Member voluntary winding up. In case of member voluntary up, the directors, in the meeting of the shareholders, the company is liable for liquidation. The meeting then passes a resolution for voluntary winding up and appoint an official liquidator. Voluntary winding up takes place in the following circumstances by the member themselves. I. Special resolution. Voluntary winding up of a company takes place by passing a special resolution by the members of the company. 2. Appointment of liquidator. In the general meeting, the shareholders of the company appoint the liquidator to wind up the affairs of the company. Assets of the company are also distributed by the liquidators. The shareholders of the company also fix the remuneration of the liquidators. 3. Final meeting. After winding up the affairs of the company, the liquidators calls the general meeting of the shareholder. The full account of the company is placed in the meeting by the liquidators. 4. Expiry of period. If the period fixed for the duration of the company in the articles has expired, the company may wound up voluntarily by passing a resolution in the general meeting. Dissolution. The liquidators within 1 week of the meeting sends the copy of full account to the registrar. The company shall be dissolved on the expiration of 3 months on the receipt of the copy of the accounts. 6. Statutory declaration. The majority of the directors make a statutory declaration to the registrar of the companies that company I. has no debt or 2. is able to pay its debt in full within a period not exceeding on year from the commencement of winding up. 2. Creditors voluntary winding up. I. Meaning a winding up in the case of which a declaration of insolvency has not been delivered to the registrar is called creditors voluntary winding up. 2. Procedure. The company calls a meeting of its creditors and appoints a liquidator. When the liquidation is complete, the liquidator calls the final meeting of the company creditors and places the full account before them. A copy of report is also sent to the registrar of the companies. The registrar, on receiving the accounts and the others documents, takes action of dissolution of the company. 3. Dissolution. After 3 months of receiving the copy of accounts of the company, it is dissolved. Heading number 5. Consequences of winding up. Consequences of winding up are as under. As to the creditors, if the company is being wound up as insolvent, the rules of insolvency apply. But if a solvent company is being wound up, all debts and claims against the company are admissible to prove against the company. As to officers, the powers of the directors usually cease on winding up of the company. As to members, alternation in the status of a member after the winding up of a company is void. As to proceeding against the company, no suit or other proceeding against the company can continue except with the leave of the court. As to assets of the company, the assets of the company shall be taken into possession on the liquidation or winding up of the company. As to shares, transfer of share after the winding up of the company is void. As to shareholders, every shareholder is liable to contribute his assets. As to servants, all servants of the company stand dismissed with winding up of the company. As to costs, costs for litigation during winding up and all costs, changes and expenses properly incurred in the winding up are payable out of the assets of the company. Heading number 6. Commencement of voluntary winding up. Voluntary winding up of company can be took place in 2 ways. A. By ordinary resolution. B. By special resolution. The voluntary winding up commences at the time of the passing of the resolution authorizing it. Heading number 7. Conclusion. To conclude, I can say that the winding up of a company means end of the company. It is proceeding under the Companies Ordinance 1984, in which all affairs are wound up. Companies Ordinance lay down 3 different methods to wind up the business of company.